Hi everyone, welcome to the fourth edition of your newsletter from the business group team. Today we're featuring a podcast and we are focusing on preparing a business for sale. Very lucky to have some of my business group colleagues with me today. So there's going to be a few of us talking and hopefully you find this super useful. Let's get into it. So first off, when a company wants to sell a business, they generally contact our corporate team, and I'm lucky to have Rees with me today. So Rees, do you want to just run through what occurs when that phone rings or that email drops in your inbox?
Yeah, of course. Thanks, Tina. My name's Rees Herrod. I'm in the corporate team here. I'm a senior associate at Wright Hassel. Generally speaking, there are three sort of sections to talk through clients when it comes to selling a business, and understanding those three aspects, I suppose, is really important to make the transaction as smooth as possible. The first one, and I think the one that we'll discuss in most detail today, is the due diligence process. And that is a prospective buyer's opportunity to make inquiries about a target business and allow them to assess the transaction they are about to embark on. Now, that due diligence process will cover a wide range of business areas, including many of the teams here. So commercial.
Interesting topic for you guys because you're looking to sell your business, but it will become very important when you then hand back to your corporate lawyers to then negotiate the transaction, because it's basically how you show your buyers that you know your business and they are able to identify the strengths and the weaknesses of your business. So I'm going to talk about three main areas. The first one is your general contracts, your general commercial contracts. Then I'll talk a little bit about data protection, and then I'll finish up with a little bit about intellectual property. So in relation to your commercial contracts, that's essentially the contracts you've got with your clients and the contracts you have with your suppliers. So with your client contracts, the fundamental thing that a buyer will want to know is how profitable they are and how long will those profits flow into the business. And so a couple of pointers is to look at anything that will bring those contracts to an end. So you'd want to look at your termination provisions and something called change of control. So when the ownership of a business changes, you need to be able to carry on that contract with your client. They're two of the main ones to flag. Then you would look at your supplier agreements, because if your new buyer is not able to run the business in exactly the same way as you were able to, with the continuation of any supply chains into the business, then that's going to be a problem. Again, look at termination. And you want to make sure that your supplier arrangements are within the bounds of what a normal business like yours would have. If there's anything really onerous in there, I'd always suggest that you try and deal with those before you try and sell your business, because it will come up. So they're two of the main points I'd probably flag in this little podcast on preparing your business on your commercial contracts. Your lawyers will probably tell you there's a lot more than that, but they are two of the really fundamentals. Data protection is going to come up on every single aspect of your transaction. What I would suggest is that you do a general audit right at the beginning of the transaction. You want to look at the type of data that you collect, see whether you are processing it all in accordance with the agreements that you've got, and have that all at your fingertips. That will absolutely be fundamental in any due diligence. And then finally, just want to touch a little bit on IP. It's very, very important for you to have at your fingertips what intellectual property you own and need to operate your business. You want to have a very clear list of that. You want to make sure that when you've got, if any of them are registered intellectual property rights, that you've got your registrations up to date. You also need to check that you've got all your websites in order and you've got all your domain names properly secured. And I'll just leave it at that, guys, at this stage.
Thank you, Buddug. I mean, we've heard everyone the importance of making sure your commercial arrangements are in place, and your due diligence certainly seems to be key to selling a business. and doing it correctly. My day job, everyone, is I'm the head of employment law. So one of the things that I'm super familiar with is cheapy. My colleague, Gemma Clark, who's with me today, also deals with cheapy because she works alongside me. And we are often asked by our corporate colleagues to advise on what employers should do if they are selling their business. What happens to these employees? What if they don't want to transfer? What do they need to prepare? So Gemma, would you like to just give an overview, very straightforward overview as to cheapy, because I appreciate it's not often viewed as straightforward, but we're going to try and keep this simple for you.
Hi there, everyone. So as Tina said, my name's Gemma and I'm a solicitor in the employment team. So yes, as Tina said, when a business is preparing for sale, what they first need to consider from an employment perspective is if the Transfer of Undertakings Protection of Employment Regulations 2006, commonly called 2P regulations, apply. And so, as Tina said, it's not the most straightforward of processes, but I'll try and give it a brief overview as to the key steps that the employer looking to prepare the business for sale would need to undertake. So the first one would be to determine if the 2P regulations do apply. And for that, there would need to be a relevant transfer. That happens in a couple of situations. So where there's a service provision change or where there is a business transfer. So if you're looking to sell a business or even part of a business, that's likely to fall under the business transfer element, and therefore there could be a relevant transfer. The next step would be what employees are impacted by the sale of the business. So again, if you're selling the whole of the business, it's a relatively simple task. All the employees are going to be impacted. But if you're looking to sell part of the business, it might be slightly more complex, and you'd need to identify the employees that would be impacted and what we call them commonly as an organised grouping of employees. And essentially to do that, you'd need to undertake an exercise to see what proportion of their role is linked to the part of the business that's transferring and make a decision on that. You might end up liaising with the buyer to understand and reach an agreement as to who you think falls within that grouping, because obviously you want to make sure it runs smoothly with the buyer on the other side. The next step, once we've got those employees that are going to be impacted, you look to collect information about their terms of employment, and that's called employee liability information. So that's a due diligence exercise looking at what employment terms they have, and you can provide that information to the buyer. That needs to be provided at least 28 days before the 2P transfer occurs, and you've got an ongoing obligation to keep the buyer updated as to any changes in that information. So there's a lot of information to be provided, but some of the things would include if there have been any tribunal claims against the company, if any employees have been involved in disciplinary and grievance procedures, and then their standard sort of terms in their employment contracts as well. So their continuous service with the company, what their annual leave entitlement is, any benefits, so things like that. Hopefully a lot of that will be in your contracts of employment already and your policies and your staff handbook. So it should be relatively simple to put it all together and collect that for the buyer.
And I think it's worth saying that, a 2P transfer can lead to high levels of anxiety in the workforce. So it's really important that you do liaise with your staff. They remain your staff until they transfer over. And some of the common queries that come up is, an employer might enjoy some enhanced benefits. That might be, for example, enhanced company sick pay or enhanced redundancy pay or a better, more than the usual statutory holiday. And what employees worry about is that a new employer won't give them the same benefit, and that's not correct. So the general principle when it comes to 2P is the new employer will step into the shoes of the old employer, i.e. the seller. And it's always worth reminding employees of that. There may well be some discussions along the way with the buyer and their reps if necessary, but do try and keep in touch with your employees, because ultimately this is quite a life-changing impact to them as well.
I think the cheapy aspect of transactions raises another really important point, because there are actually two ways that you can sell a business. The most common being a share sale of an entire company, and the other being a business sale where the assets, employees and all the contracts, etc. are transferred across to a completely new corporate entity. So what Gemma and Tina have really spoken well about there is that second option where a business is sold out of a company rather than a company itself. And that also brings with it other implications, more along the tax aspects of a transaction. Now, importantly, business sales, you have to consider VAT elements, and I have my colleague Kevin Hall here, who's a partner in our VAT team, who will probably be able to speak a little bit more about the VAT implications on structuring a transaction.
Thank you, Rees. Yes, crikey, I've got a lot to say. So if you're selling shares in your business, the VAT element is there are some implications, but the real issue is when you're selling the assets, because the VAT law requires that you charge VAT on every asset that's transferred across. And not only is this going to cause cash flow issues, it puts the VAT at risk for the buyer, because the buyer has to justify recovering it. They can't always do that. If there's a property involved and there's VAT being charged on that, the VAT is charged on the stamp duty is charged on the VAT inclusive price, and that can pump the price of the property up, and therefore the whole business sale becomes more expensive. It's very important, therefore, for businesses to secure a transfer of a going concern that qualifies to be VAT-free when the business is transferred across. Now, when contracts are put in place, there are certain steps which are required to be within those contracts, and if those steps are not there, then the VAT is going to become chargeable again, the risks rise, the prices rise, and so on and so on. So it's very important. This is time sensitive as well. It's very important to get the understanding of what kind of sale you're making correct, to try and get the understanding of what both sides are doing correct, and to get the contracts correct before you can eliminate the VAT risk. Could talk about VAT due diligence as well, but maybe that's something that we want to come on to separately.
Well, I think, Kevin, that you definitely do have a lot more to say, but I think for the purposes of this podcast, that you've given some real good snippets of what sellers should consider. And of course, they can contact you at any time if they need any more detailed advice. I think it's definitely worth us perhaps bringing in Matthew Davies, because there's also that angle. You know, lots of businesses have employees that are not originated from the UK. And so, Matthew, what's your spin on that?
I think, again, it comes back to those themes of due diligence, TUPE, and whether indeed you've got an asset or a share sale, there will be things that you, as the seller of a business, really need to be concerned about. We live in a much more international world now. The thing that all employers have is an obligation to carry out right-to-work checks. Why are they so important? Well, for some 25 years now, all employers in the UK have had a responsibility to prevent illegal working. And although the legislation has changed, we have both civil and criminal regimes now, which deal with cases where employers are found to be employing people subject to immigration control who don't have the right to be in those jobs. And the way that this is dealt with is by following prescribed right-to-work checks. The way that those are carried out have changed over time. But the applicable tests and checks that you carry out when someone starts employment, or indeed when their immigration status, if it's time limited, comes to an end, are always valid at the time that they are carried out, and they has to be either before the person starts employment or prior to the time limited permission expiring. Now, liability for getting things wrong, in other words, not for carrying out your checks properly, or not carrying them out at all, or knowingly employing an illegal worker, can be very high. Even the civil penalty, where an employer has not deliberately done something wrong, is currently £20,000 per illegal worker and is going up to £60,000. Criminal liabilities, where an employer knew or should have known that there was illegality, can involve imprisonment, disqualification as directors, and all manner of serious criminal convictions. So that's why it's important. What we need to do in these cases is assure the purchaser of a business that these things have been properly taken care of. So in your due diligence, you can expect to be asked to disclose details of your right to work checks. There will be questions and follow-ups on that. you will need to be able to explain what you have done and answer specific questions. So, for example, as part of the due diligence exercise, the buyer may want to see partially redacted copies of your right to work checks to show that everything is in order. And you will probably be required to warrant and indemnify, in relation to the quality of the checks that you've carried on, because after all, liabilities for illegal employment can carry on after the sale. If you have a sponsor license to employ sponsored migrants, again, you will be required on the sale of a business to disclose those who are moving across. You make the report on the sponsor management system if you have that. There are also obligations for the buyer. There are various different scenarios here, which we probably don't have time to get into the detail of, but these are also things that will need to be borne in mind. And when there is a change of the ownership and control of a business which holds a sponsor license, a new license must always be applied for. As I say, there is a lot of detail about how this has to work in practice, but it's never going to be an option not to have looked very thoroughly and made sure that all your immigration processes are in place if you are selling a business which holds a sponsor license.
Great, thank you for that, Matthew. And I think the one thing that really comes out of all of this is that a due diligence process can sometimes be quite daunting. There's a lot to consider when you're looking to sell. And one of the top tips that I'd always suggest giving clients when we start this process is to prepare yourself with resource behind you. Now, I know that sort of owner-managed business in particular don't necessarily want to let their workforce know that a sale is imminent, and for good reason. But having certain key employees or people and advisors that you trust to assist you with this process is very key. I know we focused on due diligence a lot, but just to touch on a couple of other aspects of a transaction. So once a buyer is happy with preliminary due diligence items, you'll be moving on to negotiate a sale and purchase agreement. And that comes back to a few things that we've discussed already. So what the transaction structure is going to be, whether it's an asset sale or whether it's a share sale, and your lawyers will be able to assist you in conjunction with your other advisors to discuss what's best for the particular circumstances you're in. Bringing back Kevin in on the VAT elements, that will be a big factor when it comes to making those decisions. And also how you're going to extract your sale proceeds. So if you're selling a business out of a company, rather than the sale proceeds going to shareholders of a company, those proceeds will go into the company that's selling it itself. So always worth speaking to your tax advisors and accountants to make sure you're comfortable with that process. I think that wraps everything up from my perspective.
Just to add 2 points. If there are VAT skeletons in the cupboard, it really makes it difficult. The buyer is going to be challenging the seller. It affects the price. We've had criminal cases because the VAT's gone wrong. We've had the wrong rate of VAT being applied, causing huge amounts of warranties to go into contracts and what have you, and the prices affect. That's all I wanted to say.
Thanks everyone for contributing today. I absolutely know we all have much more to say on our individual topics, but hopefully as you are listening to this podcast, you've realised that there is a process, and that process can involve different areas of law, and getting it right is far better than getting it wrong. So thanks for listening in today. Wait until a few months and you will hear our next